I declare open this hearing of the Legal and Constitutional Affairs Legislation Committee inquiring into the Australian Citizenship Legislation Amendment, Strengthening the Requirements for Australian Citizenship and Other Measures Bill 2017. This is the first witness, of course, in Canberra, so there's just some preliminaries that I mentioned today, and principally once and for all. These are public proceedings being broadcast live via the web. Witnesses should know that giving evidence to the committee, they are protected by parliamentary privilege, and I think all witnesses are given some information by the Secretariat in that regard. It's unlawful for anyone to threaten or disadvantage a witness on account of the evidence they give. We prefer to take evidence in public. However, under Senate resolutions, witnesses do have the right to request to be heard in camera. If that occurs, the witness should indicate to the committee why and how, and then the committee takes a view on that. If any witness objects to answering a question, the witness should state the ground on which the objection is taken, and it's up to the committee to determine that. If the committee determines to insist on an answer, a witness may request that to be taken in camera. Witnesses called for the first time should state their name, their full name, the capacity in which they appear. To assist Hansard, just make sure we all speak into the microphones, and so that we can accurately record for posterity what's said. The committee's agreed that answers to questions, if there are any questions taken on notice by any witness, should be returned by Monday the 28th. I particularly welcome Professor Rubenstein. Thank you very much for giving us your time to be with us today and to help the committee. We do have your submission, and again, thank you for that. We normally, and will again now ask you to make an opening statement, and then the committee will ask you some questions after that. Professor, over to you.
Thank you, Senator Macdonald, and thank you, Senator McKim and Senator Pratt, for giving me the opportunity of presenting personally to you this morning. For the Hansard record, I thought I would restate the sort of frame within which that I'm coming to the committee, having authored this book on Australian citizenship law, which is now in its second edition. But in addition to that academic standing, I'd like to represent my practical experience in the area of citizenship, having appeared now 3 times in the High Court on separate citizenship matters, and also in the Federal Court and the Administrative Appeals Tribunal. So I have a working knowledge of the way the Act operates, in addition to, of course, my intellectual academic interest. In addition, I've had a policy role in the past that I wanted to set out. Between 2004 and 2007, I was a consultant to the then Department of Immigration and Multicultural and Indigenous Affairs, now the Department of Immigration and Border Control, in relation to its review and restructure of the 1948 Act, which led to the repeal of that Act and the enactment of this 2007 Act, and of course it's an amendments to this 2007 Act that we are actually addressing. But I should state that I have not been a consultant since that point of time in relation to that 2007 Act to the department. But since then, and in 2008, I was a member of the independent committee established by the then Minister for Immigration and Citizenship, which reviewed the new 2007 test, Australian Citizenship Test. And I was therefore quite involved in the drafting of this report, the Moving Forward, Improving Pathways to Citizenship. And there are significant aspects of that experience that are relevant to my submissions, of course, today, as well as my broader experience. So that's just an introduction for the purposes of setting context for my submissions to the committee. And I think there are some salient points that I'd like to start with, and then there are the specifics that I'm really looking forward to developing with all of you from my submission. But I think my broad concerns are that the explanatory memorandum state in the bill that it's seeking to strengthen the requirements to become an Australian citizen. And in my view, these measures do not uniformly strengthen the Act. In fact, in my view, some of the proposed changes may indeed undermine the strength strength of the Act in its emphasis and focus. It is my proposition that the Australian Citizenship Act should be concerned with matters that are beyond Australia's migration program. And I think that these proposed changes are highlighting that too much weight is being placed on immigration policy over broader questions about membership of a democratic nation state. And I think that these changes need to be scrutinised within a frame of citizenship policy, which is affirming of the rule of law principles that underline the proper balance between executive power on the one hand and acting in the national interest, and the rights of individuals who are subject to that power. And then finally, at a time when it's important to consider creative ways to foster social cohesion and to counter the potential radicalisation of youth and indeed radicalisation of the broader community, I think that we should be thinking about citizenship as a means to encourage and promote an inclusive society. That is, citizenship has the real potential to be a cohesive device to foster a robust and democratic society. And I think the message of all of these changes are of citizenship as exclusion rather than inclusion, and of encouraging a hierarchy of different levels of membership, which subtly identify some groups as being more suspect than others. So they're the broad reasons why I would caution the committee and Parliament from passing these amendments, and the specifics in relation to residence, in relation to English requirements, in relation to Australian values, in relation to bans on reapplication, in relation to the Pledge and Allegiance, in relation to ministerial powers, are all aspects that I have further material to submit to the committee, in addition to one of the very fundamental changes, which is breaking the link of residence with birth for automatic citizenship and altering the principles of citizenship.
Current politics with that. That's a joke.
I was going to say, as many of you may have heard me saying quite a lot in the public, citizenship by birth and citizenship by descent are the normal, regular ways that someone becomes a citizen. And these are two areas, though, that are seeking to be altered here in a significant way from the norms that are necessary in a democratic society. So they're all changes. All of these changes I would caution heavily against, but they all come under that theme of citizenship, using citizenship as a form of exclusion rather than as a mechanism of creating a very successful multicultural society. And in fact, in light of that joke, I might say that one of the interesting aspects of the current attention to dual citizenship issues in Australia at the moment is that there's a very different way that one could be looking at this current issue, which is how successful we have been as a multicultural society, that within one generation we already have members of parliament, people who have committed themselves to becoming full, active citizens. What a great statement of multiculturalism in Australia, that we've now got this scenario that we're dealing with, which, as you know, I believe is an outdated section of the Constitution, but it actually represents how citizenship has been a form of inclusion, and so much so that first-generation Australians are already in Parliament or wanting to be active members. And I think everything that this bill does seeks to detract from the success story of Australia in that regard.
Professor, we do have an hour.
Great.
If you wanted to briefly...
Go through each of the different areas?
Just relative,
Yes.
if you leave
and then
the
you
committee
can ask
at
questions
least sort of
specifically, yes.
35 minutes to ask questions, but
Sure.
if you wanted to, you may well preempt some questions. If you go particularly, I think, through the first three or four that you mentioned.
Yes, so the English language, the residents. I'll start with residents, actually. I'm very concerned about this proposal to move the requirement for residents to include 4 years of permanent residence. And I'm concerned because the explanatory memorandum talks about it being a useful period to check on a person's integration into the community. But that misses that in fact is what happened in 2007 when the changes from the 1948 Act were implemented through the 2007 Act. Before the 2007 Act, you only needed to have 1 year in the previous 2 years as a permanent resident and 2 years in the previous 4 years as a resident. So in essence, someone could become a citizen within 2 years before 2007. That was part of a device historically of encouraging people to become citizens as soon as they were able. But then with the change in the international climate in terms of terrorism and the Bali bombs and aspects that were really relevant to the consciousness of Australians, the change in 2007 was to change it so that you required 4 years residence, not 2. So we already made that change in 2007. The difference between what happened then and what is suggesting now, is that that change is 4 years, including 1 year as a permanent resident. So the change now is extending that 1 year of permanent residence to 4 years as permanent residence, which in effect means that it's going to be much longer than 4 years before someone who's been residing in Australia can become a citizen. Now, my question to the committee is, if the concern is about monitoring people's residence, there is actually no qualitative difference in your capacity to do that when someone's a temporary resident or someone's a permanent resident. Those different categorisations are about the pathway to citizenship, but they're not about actually being able to do assessments on people's integration and activity while they were here. So this extra requirement for further time as permanent resident is really a message to people to say that it's going to take you that much longer for you to prove to us. It's this level of that you are more suspect to us for longer, and that is not an inclusive device. That really is one of exclusion. And there are significant individuals who are passionate about making that commitment to Australia, who may want to run for Parliament, who may want to vote, who may want to have those rights that reflect active citizenship, who will, if this bill goes through, be prevented for, in effect, an extra 3 years beyond what is already a 4-year residence requirement. Now, it's interesting just to add to the responses that I have had by virtue of being a little bit more in the media on these issues. I had just yesterday a letter sent to me that had been sent to the Prime Minister from a doctor in Melbourne who is a qualified psychiatrist who came to Australia in 2011 from Iran, a Dr. Torshizi, who wanted to impress upon me how he had communicated with Parliament because of his distress of that extra weight that he now would have to endure when he is so passionate about embracing Australia and becoming a citizen in the fullest sense. And his is just one of the myriad of numbers of individuals in society. I have colleagues who work with me at the university who are permanent residents who Australia will be so proud of in relation to their scholarship. People who Australia will with great gusto say are our own, but who will be prevented under this measure from becoming a citizen sooner, and for Australia to benefit from their citizenship sooner. So I think that the caution about giving people more time to be assessed is overstated, because we already have that, and I think the detriments to the many people who want to make that commitment to Australia sooner will outweigh the supposed benefits in having that extra time in terms of residence as a permanent resident. So that's the first point in relation to residence. In relation to English requirements, this again to me appears to be a misrepresentation of what the current scenario is. And as I said, I have quite deep involvement from having been involved with this review of the citizenship test back in 2008 and hearing many submissions in relation to what was then the new test, which had a booklet. And the booklet, since our recommendations, has been modified in relation to the focus of the booklet, but the level of language of English of that booklet, the evidence was overwhelming, was more than a basic level of English. That then led to the booklet also being promoted in other languages, but the testing related to the current level of the booklet is at a level that is higher than basic English. So there is an undercurrent of these current proposals that we're not testing at a sufficient level at the moment, and I would say that that is totally contestable, that the language of English in the citizenship test at the moment is more than a basic level of English, and so that the competency that people are already having to show in order to pass the test now to become a citizen.
So it's been inaccurately characterised. characterised as basic?
Well, the reason why it's referred to as basic is that the legislation only requires a basic level of English. So that in order to become a citizen, you need a basic level of English.
Yeah, I understand that, but you're saying
That the
test
current
itself
test is more than basic.
is not actually basic, even though
Yes.
it's only basic that's required.
Correct,
by the
that's exactly
legislation.
right, yes. That's my interpretation based on the evidence that was presented to the independent committee in relation to English language proficiency. So I would certainly state for the record, I am not an expert in English language proficiency. What I'm reporting to the committee is what those experts said to us, and it was recorded in this report that the level of English was higher than a basic level of English.
So we've got some witnesses in this afternoon. We'll be able to ask about that.
Yes.
How would you characterise the kind of question we need to
They're at
ask
a Year 12 level of English in terms of comprehension of the material that they're asked about in English.
in the current test?
In the current test, yes. So that the material that people have to become clear about in answering the citizenship test and then reading the questions only in English is at a level where they would have to have a knowledge of English that is of equivalent to a Year 12
Yeah,
English.
not a tertiary entrance, which is what they're getting it to, but at least Year 12. Yeah.
That's my understanding of what was
that makes
represented to us. And the current test, in effect, is therefore assessing English. And in fact, one of the recommendations of this report was to maintain the combination of English language testing with the rights and responsibilities of citizenship testing, because it then makes it a cohesive package in relation to encouraging people to become active citizens, in the sense that you are enhancing both their English and their knowledge of citizenship in the process of passing the test. So my concern about adding a separate English test is twofold. One is it's an incredible amount of money, and that money would be better spent enhancing your English language education for settlement purposes, to encourage people to get to the language level that they need to pass the test. But I think it also sends this same message of exclusion, of a further hurdle that is saying you have to prove to us in a way that is more than necessary for an inclusive society. So on those two levels, I think that this desire to change the requirement for a basic knowledge of English to a higher level is not consistent with that inclusive notion. And our committee at the time represented the views that came to us, which is that most people were comfortable and affirmed that basic knowledge of English in an understanding that it provided them sufficient knowledge to be able to exist independently in the wider community. That is essentially what you want, that they are able to live full lives with enough to live independently in Australia, not rely on others, with a basic level of English. So my recommendation would be to resist this change to a high level for those reasons. The Australian values section, I think, is highly concerning. This is now wanting to add in a new provision into the Act of requiring applicants to sign an Australian values statement, and is actually amending the criteria for citizenship to prove that a person understands and adopts Australian values. Now, first of all, again, what the current system is, that anyone who becomes a permanent resident already at that point has had to sign a value statement. So that's part of our migration policy system, to distinguish it from citizenship. They do that to become a permanent resident. And if you've had the 4 years of residence, including 1 year at the moment as a permanent resident, and that person has already signed on that statement, there's a question as to what benefit is added by getting them to sign that statement again. And so there is just what is the actual value of signing a statement in relation to proving that commitment. But I also think this gives too much power to the executive in terms of determining what Australian values are, because the power is in the executive branch of government. There's not a statement in Parliament. The amendment to the Act is not telling us what those Australian values are for the purpose of the Act. It is leaving it to the executive to determine that through regulation. And in essence, that undermines the rule of law principles that I want to come back to. But in essence, and I'll come back to that in terms of external review and the extra power given to the executive, but just even in this notion of Australian values, giving the executive the power to determine that in a way that is determinative of who becomes a member, does give off the air of that sort of dictatorial state framework of managing in an extreme way the values of society. Now, there is a key value, which is, of course, a commitment to the rule of law, which is already central to this Citizenship Act and already central to the citizenship test. So if that commitment to the rule of law is not enough, I'm concerned what else the proposal is seeking to change. And perhaps to jump to that broader principle in relation to the extent of extra executive power that is being provided by the extra discretions to the minister here, but also to remove the right of review before, or to override an administrative appeals tribunal principle, that totally distorts the balance of our administrative law system that has been developed since the 1970s of keeping the executive to account. And as I said, as I've been saying in relation to my commentary about this, there is an irony here that at the same time as them saying that they want to include Australian values in citizenship test, they are this proposal directly undermines the most central Australian value of the rule of law. So from my terms, they're failing a citizenship test in the concept of trying to amend the citizenship test.
Isn't I think that's what Parliament decides?
But this isn't.
It's the executive. If the Act had a list of Australian values that were relevant to citizenship that the Parliament could agree on, then there would be public discussion about that. But in essence, it's giving the executive that power to make those determinations. And then the question would be how our rule of law system keeps the executive accountable, and that is usually through a tribunal, a review before the tribunal, which the Minister is now saying in this Act will be will be able to be overridden by the executive. So the check against a supposed system where you enable in this situation the executive to make that list, the check on that is also being taken away. So it's a double undermining of the rule of law, which is really concerning in terms of democratic notions of citizenship that we should...
Professor, having given you an open slather, I'm now going to just...
Take me to some
we do need a bit of time to ask questions. So was there any other points you particularly wanted to raise?
Yes, this notion of changing the concept of a pledge to a pledge of allegiance rather than loyalty and commitment. I'm concerned about that change of language. I understand from a constitutional point of view that the government may possibly, I don't know this, but may possibly have received advice in relation to this legislation fitting under the aliens and naturalisation power, and a lot of the discussion in the High Court about who is or isn't an alien, which will be relevant to its interpretation of Section 44, I might add, is around this concept of allegiance. Now, I see that when the Act introduced the concept of loyalty and commitment as a progressive step to recognise that allegiance traditionally has been thought of as an exclusive notion. Okay, so that in historical terms, and at the turn of the century when Section 44 had been introduced to the Parliament, that concept of allegiance was an exclusive one. But we have seen throughout the world over the years a move towards an acceptance of dual citizenship, an acceptance which in every other respect except for Section 44(1) of the Constitution has been affirmed and adopted in Australia. We now enable all Australians to become dual citizens without losing their Australian citizenship. So that change to loyalty and commitment is a recognition that you can actually be a member and a citizen of more than one nation state without that undermining your loyalty and commitment to Australia. And I might be starting to sound like a record, but the analogy that I really feel helps people understand the difference is that if people think of citizenship like marriage or a form of marriage, whatever that marriage might be in terms of the sexuality of the people, but if people think of it as that long-term commitment to one person, then they think of citizenship being sole allegiance. But I think that we have moved to a point, and Australia has affirmed this, of citizenship being more like parenthood. You can have more than one child without that undermining your loyalty and commitment to each of those children. And in the same way, the concept of citizenship in a modern international world, and as I've also referred to the committee, I've edited a book on allegiance and identity in a globalised world, and the committee has the introduction to that. We have moved to a notion where unless there is an actual direct conflict between two nation states, which we traditionally think of in the most sort of fundamental way of one nation state being at war with the other nation state or doing something directly to undermine the state as an entity, then we've moved from that notion of exclusive allegiance to multiple connections. And I fear that the reversion of the word allegiance in there is reinforcing what is now an outdated notion of exclusive allegiance, which does not sit with every other aspect of citizenship law in practice in Australia, except for Section 44(1). So this change, to me, I would caution against. It's not necessary, and it sends the wrong message again of exclusivity over multiple forms of commitment. But I'm happy to answer any further questions.
Thanks, Professor. Deputy Chair, Senator Pratt.
Thank you, Professor Rubenstein. On page 7 of your submission, which is 49 in our documents, you go through your concerns about how this bill alters the principles of citizenship by descent and adoption. And I guess it should come as no surprise that members of Parliament are somewhat naive about the fact that these are fairly universally held principles. And it would be my understanding that they're important because otherwise you get in the way of families being able to conduct their businesses, be a family unit that might need to operate between two countries, but you might also be in danger of leaving a child stateless.
Correct.
So, for example, when Britain confers citizenship by descent, it doesn't really know whether the child of a British parent or father has an alternative citizenship, do they?
Exactly. It's an inclusive device. It's exactly about enabling people to be included, which is consistent with this theme about citizenship policy generally being about inclusion rather than exclusion, enabling people to be connected to the nation state, which they may have some connection either through family, as you've just identified, or through birth or through residence.
So what are the dangers of tightening up these kinds of provisions in terms of the ramifications for families and children?
Yes, so thank you for reinforcing that point. The dangers are that you effectively mean that there will be some families who will be unable to travel as a family unit, perhaps reside as a family unit in Australia in relation to some of the members of the family being citizens and others not. So there's that basic, as you said, right of family life together that may be impacted by something like this. And then, as you also alluded to, there's the more fundamental question of citizenship, of statelessness. Now, interestingly, the Act does have a provision in relation to protecting against statelessness, in the sense that the minister currently, for someone who is born in Australia, may apply for citizenship by statelessness. But I can put on the record that I'm currently involved in a case at the moment, so that it's still pending, but it involves a child, and I won't say the country, just in terms of just broad principles, born in Australia, whose parents are from another country, and the other country is not enabling that child to become a citizen, and the government is resisting that application on citizenship on the basis that there is a formal entitlement as a matter of constitutional principle, even though practically, and again, I won't go into the circumstances, but there is this preference to exclusion over inclusion in the way that the current government interprets even the statelessness provision.
Can I ask how long that child has been living,
So this
born
is
here?
Yeah, so the child who was born here didn't live here for very long. The family actually ended up having to leave the country for personal reasons to do with other family members who needed their help.
Nevertheless,
But and what is interesting here is that child is now vulnerable to trafficking, to other issues internationally by virtue of not having formal identification, which is part of what citizenship also protects you from in an international regime. So it's not only the actual residence aspects, but in fact the nature of the international principle that everybody's rights are most secured by having a nation state connected to it, so that if you don't have that, you are vulnerable to all of the unfortunate consequences.
And in large part, we can only therefore make these decisions as a nation when we let people in the first instance.
Yes, yes.
Rather than
at the citizenship decision about citizenship. That's right, thank you. It's really, that is exactly the point here that I started with, about the difference between migration policy and citizenship policy. Now, I've written about this. Australia's history, unfortunately, is totally caught in migration policy dictating citizenship policy. But it's not consistent with broader principles of citizenship. And these two changes, both for citizenship by birth, automatic birthright citizenship linked to residence, and the descent provisions, are pushing us further away from the norms of citizenship of inclusion for birth in territory and descent. Now, we already moved a little bit for citizenship by birth, because in 1986 the change was made to say that pure birth was not enough. You needed a parent as well to be a permanent resident or citizen. This is pushing us even further, because it's saying that the safety net that was provided at that time of the move was that if you were born here and neither of your parents fit that category, and you continue to live here for 10 years, as in you have your residence as well, then you automatically become a citizen. This bill seeks to change that by saying that there are other requirements, including lawful residence. So it's coming back to migration policy rather than the citizenship policy of linking birth and residence as a normal way, as a standard universal way of recognising someone as a member of the community.
Yeah, that makes very logical sense. You say in your submission on page 2, and this is where we started, citizenship has the potential to be a cohesive device of fostering a robust democratic society, rather than as an exclusive tool engendering a hierarchy of different levels of membership and subtly identifying certain groups as more suspect than others. Now, we certainly heard evidence yesterday in terms of the personal stories of people who are affected by the 4-year residency requirement, where they were otherwise about to meet the existing requirement. And the level of exclusion and frustration they feel attached to that. Even though some of these people are married to Australians.
Have Australian
they are
children.
Indeed permanent residents. They are committed to a long-term life here, and according to their current visas, they have a right to a long-term life here. And yet we somehow seem fit to
further
to exclude these people from citizenship. Could you expand on, in academic terms, what that hierarchy of differing levels of membership means for our national fabric?
I think it's really important, and I've talked about this in other contexts, of the move to citizenship from subject status. So at the turn of the century, and all of the discussion around Section 44 was from a time in which we were subjects of the Crown. And Australia's history on this is really interesting, because we stayed subjects, British subjects, up until 1987. But from 1949 we became Australian citizens as well as British subjects. And my argument is that when we became Australian citizens, it also represented the shift away from the concept of subject status. Now, subject status is about the Crown being all-powerful and benevolent towards its subjects and extending protection over its subjects. And in fact, those other aspects that are confusing people about Section 44 in relation to someone who is entitled to the rights and privileges, but who may not be a citizen of the other country, is because the subject often, the Crown often used to bestow to denizens these rights of citizenship if they had lived long enough in the country, even though they weren't formally British subjects.
Yes.
So that's the foundation to this concept, that a move to citizenship is a move away from the benevolent Crown to the democratic framework of a nation state, where those who are in the executive role are accountable to the people. So it moves to citizenship being about equality between the executive and the people. And so once you reinstate these hierarchies of making it more difficult, I'm saying we're reverting back to that subject notion of the Crown for the executive.
Well, we are essentially excluding members of the Australian public from our democratic processes, aren't we? When they are in all respects
full members.
Permanent and full members of the Australian community.
Indeed. And in fact, you know, often there are people who have referred to as being Australian in all but law. And that is a recognition that there are times when people don't fit within the formal constraints of a Citizenship Act, but who we look around as full members of the community, but are being prevented so that they work, they pay taxes, they participate in every other respect except for those key citizenship aspects, which are voting, and of greater freedom in relation to their travel. So the key difference of being a permanent resident to being a citizen is, of course, voting. But the other is that when you leave Australia as a permanent resident, you need a permit, a re-entry permit. Now, some people have built into their visas a re-entry permit for a particular period of time. They can re-enter for a particular... But that's not permanent re-entry, it's permanent while you're here. So this is where we get back to migration policy rather than citizenship, because there is that notion that when someone is a permanent resident, you still have the capacity to deport them, and you still have the capacity, if they leave the country, to stop them returning. And so that's about immigration control than it is about citizenship. And to add to the essence of what you are asking about in relation to permanent residency, unless within that time the government has a reason to deport that person over those 4 years, then the further requirement to wait to become a citizen goes against every step that has been historically part of the inclusive multicultural society that we have affirmed, and as I said earlier, is represented in our wonderful parliament now in terms of the diversity of multicultural experience of citizenship. It would move away from that and have a negative consequence in terms of those individuals not feeling equal members of society, because we're telling them they're not equal, they're not entitled to continue to live here with the fullness of citizenship.
Well, for a period of time.
For a period of time, exactly. No, not forever, absolutely. But it's a longer period, and the question is what benefit is gained that isn't otherwise gained from the 4 years of residence anyway for checking out those migration-style type issues.
I've got further questions, but I'm certainly happy for others to have the call.
Senator McKim, about 10 minutes.
Thanks, Jim. Good morning, Professor Rubenstein. Thanks very much for your submission and for your very clear evidence this morning. Look, I just wanted to ask you about your views on the way the government has framed this whole move to change some of our pathways to citizenship, and just refer you to the 2014 discussion paper that arguably kicked this whole move off. Now, on the first page, you see a comment from the department about a world in which terrorists are reaching out to our community, and then you get a little bit further into it and there's a whole section on the obligations of citizenship in an age of terrorism.
Is it the one that has the test for strengthening, or
it's
your rights, your responsibilities?
Your right, your responsibility.
I've got that right here too.
Yeah, and I'm just on page 5, and at the bottom of the page in the section headed "The Obligations of Citizenship in an Age of Homegrown Terrorism," the department says as part of an overall strategy, that is a strategy to deal with terrorism in Australia, we want to examine how we might build on existing citizenship laws to help deal with the terrorism threat.
Yes.
Now, I heard your comments you made earlier about the potential impact of these proposed changes on social cohesion in our country. But can you see any way that changing the laws in the way that the government's proposing to do will make Australia any safer?
No, and thank you for asking, because I think that's right to put this in the context of the evolution of citizenship over the last 2 years. That inquiry was around the time that the changes were made in relation to the stripping of citizenship from dual citizens. And actually that is really another interesting point in terms of the current discussion about dual citizenship in Australia. I've explained how in every other respect except for Parliament you can be a dual citizen. But one of my other areas of writing is in relation to now the fact that dual citizens are more vulnerable than single citizens because as a result of those changes at the end of December 2015, only dual citizens can have their citizenship stripped in those contexts. Two people can be doing exactly the same thing, but only the dual citizen will have their citizenship stripped. The sole Australian citizen would continue to be an Australian citizen, so that reflects also badly on this equality of citizenship. But it is the precursor very much to this bill in line of this discourse of strengthening the test as a way of strengthening our security. And my view is that it's actually going to be totally counterproductive, that it does the exact opposite. It is this notion that you are making more suspect those people who are open to radicalisation. You are not embracing and encouraging those people to become full and active citizens. You're saying, wait, we're going to keep checking you for that much longer to ensure that you fit our categories, in a way that is not affirming of a rule of law principle of inclusion, and that there are better ways to be dealing with what is a real problem. I'm not denying that concerns about terrorism and about radicalisation are real problems, but a citizenship test is not the way to deal with those things, and as I said, is counterproductive. There would be much more inclusive, beneficial ways of engaging with those communities that will assist in dealing with that radicalisation than effectively saying to them, we're going to continue to make you more suspect for longer. And so, yes, I think that that discussion is concerning, that citizenship should be, as I said at the beginning, an inclusive device as opposed to an exclusive device. And by using it as an exclusive device in the context of terrorism is counterproductive.
Yeah. Thanks, Professor. That's very clear and comprehensive. I wanted to ask you about the retrospectivity contained in this legislation.
Yes.
So you're obviously aware that the government's policy now is that the new waiting periods kicked in as of 20th of April, when the announcement was made. Do you just want to, can you give us a broad response to that,
really
and what some of the impacts of that might be on people?
I think that's very concerning, first of all, on a rule of law notion. So if we are really committed to rule of law values, and if this mantra is about improving an understanding of Australian values, that strikes directly at a fundamental principle of the rule of law, which is that you are able to follow the law as it is presented. So this purported, I am questionable as to whether it's valid, this purported use of the policy as of the 20th of April, to me, just undermines any sense of the rule of law principle, that law is that the current act is in place, and the capacity to stop processing on the basis of a new policy that has not actually been supported by legislation is totally undermining of the rule of law. And if it were brought before a court, if there was a matter, if someone had the wherewithal to go before a court now with a current application that is being prevented from being processed, I would be very keen to see what the court would say about the lawfulness of putting a hold on that.
So would I.
Yeah.
And I'm sorry if I'm interrupting you here, Professor, but I did want to ask you about that because it's correct, is it not, that there's no time frame within which applications need to be processed by a department currently in the Citizenship Act. However, I presume you're referring to the capacity for someone to go to the courts arguing that there's been an unreasonable delay. Is that right?
Yes, there's a framework of that. But even the accessibility of making the application, I haven't tried myself to use the system, but what has been reported to me, and would need to be tested, is that people can't even put in an application now if they don't satisfy the new policy grounds. Now that, to me, is unlawful, because the legislation as it currently stands says if you meet these criteria, you should be able to apply. Whether the government processes you is another thing, and is another aspect of an unreasonable delay in processing. But not even taking an application, to me, is a direct affront to being beyond law. It's the law enables you in those circumstances to at least apply, but my understanding is that, and it might I'd be interested if you get to meet with the representatives of the department to ask them.
Well, in fact, they're coming in this afternoon,
Great.
Professor
If you can
Rubenstein,
ask them whether people
I
are prevented from even making an application, because to me that strikes directly as beyond power, ultra vires. There is an act which says that these are the criteria, and individuals should at least be able to submit their applications.
Would it be a different circumstance if the department was accepting applications but refusing to process them?
Well, then I think that they are two different matters. I think, though, that the principles would still need to be assessed in relation to the processing of the applications. There has been a separate federal court decision in relation to an unreasonable delay in processing of citizenship that is in relation to those people who have been prevented from taking the pledge, for instance. There are a myriad of ways, and the federal court, in my understanding, I don't have the case name in front of me, but the Refugee Council of Australia would be able to tell you more about it because they were involved with the running of this case. And the federal court was clear that there was an unlawful delay and that needed to be processed. So that philosophy is consistent with a very fundamental basic rule of law principle that the government can't introduce policy that is not consistent with current legislation. So policy would be unlawful in my respectful view as a pure matter of administrative law.
Thank you, that's very helpful. So you've gone to the rule of law issue as it applies in your view to the retrospectivity, but you've also in your submission made comments around the rule of law in regards to the proposals to increase the discretionary power of the minister, particularly to overturn AAT decisions in certain circumstances. Can you just talk us through your concerns on what I would regard as a power grab by the minister? That's my words, not yours, of course, but that's how I would regard it, particularly as the minister already has quite extraordinary discretionary powers at his disposal at the moment.
Yes, indeed.
So in broad terms, what are your concerns about that? And I note that in your submission you did say that you had a level of expertise in administrative law as well as citizenship.
Yes, indeed. So I teach administrative law to undergraduate students, and also an elective course in issues to do with administrative law directly actually linked to citizenship. And I am very concerned about these moves. You referred to it as a power grab. I actually refer to it about this move back to the concept of the Crown as subject and having immense power, which is not consistent with a democratic balance. The rule of law is about the government being as accountable as the people to law, and this is giving the executive that extra bit of power that becomes less accountable, and so is very undermining of that basic notion. Moreover, when the tribunal makes decisions, it's standing in the shoes of the minister, using the legislation and the guidance from Parliament in relation to making decisions about individual cases. So even though minds can come to different conclusions in relation to the same evidence, it's still about someone being guided by Parliament's instructions as to what is relevant. They're not making their own individual personal decision out of any context. A tribunal member is bound by the Citizenship Act, and that tribunal member's decision can be appealed to a federal court. So if the minister is concerned about an Administrative Appeals Tribunal decision, that minister has the power, as any individual does, to appeal that decision before the federal court, and the federal court then makes a determination as to whether that tribunal decision was lawful or not lawful. And if it's not a question of lawfulness, then Parliament should be building in more to the statute what those specific aspects of character, for instance, which is generally what a difference of opinion may occur over. There must be more specific guidance to the minister and to someone who stands in the shoes of the minister, not giving the minister, him or herself, this ultimate power to make a decision as to someone's character. There has to be some lawfulness in that, and this move is taking us out of the bounds of lawfulness.
Last question from me, Chair, if that's okay. In response to some criticisms along the lines of those that you've just outlined, and for that matter many others have outlined in regards to this legislation, the government has made much of the fact that there'll still be an opportunity for a judicial review. However, we did hear evidence from a number of witnesses yesterday in Sydney that the precedents set by the federal court in regards to assessing decisions made in the public interest mean that it would be unlikely that a large or a significant proportion of any decisions the minister made to set aside AAT decisions would actually be reviewable by the federal court. Do you have an opinion on that?
Yes, so I think that this comes back to another core issue in our constitutional framework, which is a separation of powers, that the courts are, of course, limited by what the Parliament provides for them in terms of an interpretation of those provisions. But there is that concern by making something broad and a reference to the public interest is more curtailing of the judicial role of being able to interfere without direction as to what is in the public interest. And in light of the context of national security, we know that courts always err on the side of deference to the executive in relation to national security. So if everything is framed here in terms of national security, you are putting immense power in the executive, even with a right of review before the court, because of that notion of separation of powers. But in my mind, that then comes back to that notion of undermining those broader constitutional principles that have put separation of powers principles there in the first place, which is keeping the executive accountable. So it's a distortion of that balance, and the federal court would be respectful of the separation of powers in a way that would undermine the accountability, in this instance, of the executive.
Thank you.
Thanks, Senator McKim. Professor, the executive power to ministers, some would argue that, of course, in changing circumstances like security, and it does really change by the week, we're experiencing situations now that we've never experienced before. Do you concede that there is some time when the executive power needs to be exercised in the way suggested? Now, like you, well, sorry, not like you. I'm comfortable with executive power now, I have to say, with the current minister, but if there's a change of government, a change of minister, perhaps I'd be the first one to be arguing your case on executive power. But do you think there is a...
Look, Senator Macdonald, I think this is a really interesting question. There are two aspects to it. One is about the place of the executive government protecting the national interest in the context of security, which is a real issue. But with respect, that has been a human issue for time immemorial. It's not as if it's the first time that we're dealing with terrorism. The extent of it may be different. I'm not denying that, but all societies in different ways have to deal with fringe elements of whatever nature. And so finding the proper balance in a democratic framework is key to maintaining a commitment to those principles. So I think that is one aspect of it. But the second aspect in relation to it is that it is so easily used in a political sense that we should be cautioning against it. And this is where I'd like to end, in the context of citizenship. So in the criminal law framework, we've seen an altering of those balances of protections of rights of individuals in relation to questioning and so forth. And there's been real concern and proper attention to the proper balancing in a criminal context. And I think that is appropriate, that there are ways for the executive to manage questions of security in the context of our criminal law system. But I think what is so fundamentally concerning is when you move that into the range of citizenship, because you are bringing then citizenship into the realm of punishment or criminality or aspects by stripping people of citizenship in these circumstances, which was my earlier reasons for really resisting those changes. But also here, you're using what is traditionally a mechanism of inclusion for exclusion. And I'm not saying that we don't deal with terrorism. I totally agree with you that the executive has responsibilities, but it should stay clear of citizenship as the mechanism for doing that.
I'm sorry, but there is a view that they're interrelated, but that's obviously what's
in the migration sphere, but not in citizen.
Well,
in my view.
Okay, we'll hear some evidence on that later.
Great.
Look, retrospectivity, I generally share your view, but I think you might agree that regrettably it's becoming all too common now, and in the last couple of decades there's been a lot of governance by media release that's later adopted or otherwise by Parliament. And I must say, with all due respect to academia and the law societies, etc., the opposition to retrospectivity seems to be a fairly selective in approach. Do you object to retrospectivity in every aspect, or is it only in these sort of what I might call social issues that it becomes more important?
No, with respect, I would not be selective at all. I think it's a basic fundamental principle of democratic society that you cannot be responsible for something that was unlawful in the past. It has to be a prospective notion. You have to have knowledge of the law to be able to then be in breach of that law. So it's not selective at all. I can't think of an instance where I'm happy for you to try and give me an example of where I would be accepting that someone in the past, there may be a principle in relation to international conventions against genocide or crimes against humanity that are so fundamental to the core of human existence that might have deemed to be in existence. But that's a much broader discussion with respect. So, but in principle, I think any parliament should look very carefully at anything that leads to retrospective rights degradation.
Thanks for that. Who do you think is the right body to determine national interest?
Well, a parliament is our representative body. Not the executive is, of course, a branch of our parliament, but our parliament as a whole, which enables the people to be represented fully, is the body to deliberate the national interest.
Okay.
As we're doing here today.
Thank you, and thank you for the opportunity to contribute to that assessment of the national interest in relation to this bill. I encourage my students to think of themselves as active citizens, and a parliamentary framework like this is a perfect opportunity for individuals to feel that they may make a contribution to the wonderful work that you do as our representatives. Thank you.
This is a wider argument that we've got time for today, but sometimes the courts or other groups appear to be sole arbiters of what is right and wrong.
Constitutionally
they
speaking,
would say within the law.
That's right.
But in determining the law, there's also this view around.
Yes, we could spend the whole day talking about this, Senator, in terms of the proper balance between assessments of fundamental principles in a democratic society. It's an anti-majoritarian notion that the courts do have a role to deal with what are negative majoritarian concepts that we're seeing around the world at the moment in terms of promotion of hatred.
Bad as it is.
And those sorts of representations of undemocratic concepts by a majority are really concerning, and I've implored our leaders to take that on.
So who says it's undemocratic? Academia and the courts, as opposed to the people in a democracy saying it?
Well, I think that those individuals are drawing from age-old wisdom developed over centuries in relation...
But individual voters don't have, you're saying?
Well, individual voters are equally part of that thinking process, but there has to be a point where a society, in order to continue to exist in a civilised manner, needs to place some principles as fundamental.
In other persons' views of a civilised manner.
Yes,
Yeah.
absolutely.
Okay. Look, Professor, do I credit you or blame you, depending on your view, on the current Act? I mean, clearly the current Act is one that you had...
An earlier version of it, yes. So the 2007 version, when it was first introduced, there have been several amendments since that I have come before the committee to resist, but as it was enacted in 2007, I had been a consultant to the Parliament in the drafting of that 2007 Act when it first was tabled. There have been changes since, so please don't credit me with everything that's happened since, but I have participated since in trying to influence the Parliament's considerations on these matters.
Well, clearly democracy disagreed with your 2007 iteration. Professor, you talked about before that people now have to prove their right to citizenship.
Yes.
I think you were referring to the 4-year
the permanent
issue.
resident, yes.
Do they have to prove, or is that a time allowable for others to disprove their entitlement to citizenship?
In practical terms, those 4 years as permanent residents are extra years of residence for people who already had to be here for 4 years. That was my point. But in terms of what extra capacity it would give the executive during that time, it gives them more control in an immigration sense, because it would then enable, in that extra period of time, if something comes to the executive's attention that they want that person to no longer reside at all in Australia, when you're a permanent resident, you can be deported. That's the key difference.
For reasons, I mean, if an executive did do that,
yes,
one would hope it's for very, very sound reasons.
Well, we have quite a few instances of individuals who've lived every part of their life except for instance, the first month of their life, and have had no experience in the other formal country of citizenship, who have been deported for acts that other Australian citizens would not be deported for because of the fact that
they were not citizens.
Correct, and so that's using criminal law as a citizenship law as a criminal sanction. Given that that person, in every other respect, has only spent their life in Australia, their values, their experience is equivalent, except for say their first 28 days.
It does depend on what value you put on Australian citizenship, and I think most Australians would think that that is probably the ultimate value that you can ever have in Australia, as being a citizen of this country, which in times gone by has been,
it's the fullest form of membership.
Downgraded a bit to being, filling in a form.
Well, I would dispute that. I think a lot of people take on citizenship with such passion and energy, and as I said, our Parliament at the moment represents that.
I'm agreeing with you on that. But I mean, it's almost the highest thing you can achieve in Australia.
Yes.
Is citizenship. Which
is why we can use it as an inclusive device rather than an exclusive device.
Indeed, but it's one that must be carefully granted.
Indeed.
And I guess it's
I'm sorry to be zipping up my folder, but I am actually boarding a plane in 30 minutes, so I unfortunately... the committee was very kind in putting me first.
You're doing what I should be doing as chairman and looking at the clock. And look, Professor, we'll leave it there. Thank you very, very much.
Thank you very much for your time and for your interest in my submission. I really appreciate it.
Okay, appreciate it.